Namaste, dear friends. Welcome to my YouTube channel. Today, we'll be discussing an important judgment, that is the Beru Bari Union Enclaves case 1960. It was the year 1947 when the partition was to take place between India and Pakistan. In order to avoid conflicts and biased division of the land, Britain's Cyril Radcliffe, who had never before visited India, was appointed as the chairman of the Boundary Commission. In order to decide on the partition, which country gets how much land, it was agreed that the land will be divided on the basis that the Muslim dominated regions were to be given to Pakistan and the Hindu dominated regions were to be given to India. Territories were also divided based on the boundaries of the Tanas. Based on this, a report was submitted on 12th August 1947 and the award granted to the countries were called Radcliffe Awards and the line was known as the Radcliffe Line. Lot of disputes rose because of this partition, and in order to mitigate the same, a tribunal known as the Bagate Tribunal was set up in the year 1948. Many regions like the Boda Thana of West Bengal were left out by Radcliffe during the partition, which were then awarded to India. In 1952, Pakistan started raising disputes regarding the Beru Bari region of Jalpaiguri Thana and started claiming that it has to belong to Pakistan. It was observed that indeed there were a lot of errors in the division, and in 1958 the Prime Minister of India Jawaharlal Nehru and the Prime Minister of Pakistan Feroz Khan Noon entered into an agreement known as the Nehru-Noor Agreement, as per which Beru Bari was to be divided into two halves, the north region, that is the Pachaggar region, to India, and the south region, that is the Beru Bari region, were to be transferred to Pakistan. This was on the basis that the entry 14 in list 1 of the 7th schedule gives power to enter into treaties and agreement with foreign countries and implementing of treaties, agreements and conventions with foreign countries. It has to be noted that it was an executive decision and it had to be ratified by the parliament before it was enforced. While the Beru Bari region was populated with large number of Hindus, the then Chief Minister of West Bengal, Bidhan Chandra Roy, and the people who got to know about the agreement were unhappy with the agreement. The people of Beru Bari said that they are ready to give their blood and life, but not Beru Bari. More than 12,000 people cut their thumb finger and wrote letter to President Dr. Rajendra Prasad. Dr. Rajendra Prasad, who was unhappy with this, under Article 143 approached Supreme Court for judiciary advice with regards to this matter. He had two main questions, that is the law under Article 3 enough to transfer land to another country, and whether amendment is necessary or not to enforce the Nehru-Noor Agreement. The Supreme Court stated that under Article 3, Parliament may by law create new states and alter the areas, boundaries or names of the existing states, but nowhere it is mentioned that the land can be transferred to another country. The Supreme Court highlighted that law has no synonyms. Hence, Article 3 is not enough to transfer the land and an amendment under Article 368 was essential. Article 13C only gives the power to expand the land and not to reduce it. Union also argued that the preamble states that our country is sovereign, democratic and republic. That is, it is the government of the people, by the people and for the people, and the Prime Minister being the representative who has been elected by them should have the power to decide or alienate the land on behalf of the people. The court in this decision stated that The preamble was not part of the constitution, but it was just a reflection of the vision of the constitution. So, this argument was not taken into consideration. But later on, this perception was changed in the very famous Keshwananda Bharati case. It was also decided that in order to transfer the land to another country, an amendment was essential. Hence, the Ninth Constitutional Amendment Act was passed in the year 1960 under Article 368 of the Indian Constitution. The first schedule, which was having the list of the Indian territories and states, were amended and the Nehru-Noor agreement was enforced. The important facts of this case was that Article 3 alone is not enough to transfer the land to another country. It has to be amended under Article 368. Secondly, preamble is not a part of the constitution. It is just a reflection of the vision of the constitution. So that was Beru Bari case for you guys. If you liked this video, I will like you all to take a moment to like, share and subscribe to my channel for more such videos. Thank you.